number 76, ex-rel Negron versus Superintendent. Counsel, given our public health protocols, I assume you've been instructed to stay where you are and argue from your table?
Very good, thank you. If I could reserve 3 minutes for rebuttal, Your Honor?
You may.
May it please the Court. The text of SARA is awkward, unwieldy, and ambiguous, and can be read in two ways. SARA's history and its remedial purpose show that it was intended to be read the state's way, namely as applying to all Level 3 sex offenders
Counsel,
on community supervision.
in that reading up here,
Yes.
in that reading, it seems to me you have enumerated offenses, and then you have an aggravator, right, under 18 as a victim. And the question is then, are we going to expand the pool within those serving a sentence for the enumerated offenses to include Level 3? Or are we going to create an entirely new category of Level 3 offenders subject to the mandatory condition, right?
That's right.
So if you look at DIAC, and I know you talk about it in your brief, the history of kind of managing this sex offender process and has gone through SORA, then SARA, but then also this Chapter 568, right, which came after SARA. And 568 was meant to sort of address the problems they were having with finding compliant housing, particularly for Level 2 and Level 3 sex offenders. And that, what became that legislation first passed the Assembly in 2006. So isn't it somewhat, as you would say, counterintuitive to think that the legislature would expand the pool of people subject to this additional restriction, which in the legislative history of 568, they specifically say exacerbates this problem that they were trying to address a mere year before they passed this legislation?
I don't think it's counterintuitive, Your Honor, and the reason I don't think it's counterintuitive is because when you look at the legislative history of the 2005 SARA amendment itself, it really embraces the state's reading of SARA as a remedial statute.
Well, I think you could read that as a shorthand for a sex offender who's been convicted of one of the enumerated offenses. I think you really have to look at the text, and, you know, in that regard, in 259C15 is kind of an analogous provision. Would you read that provision, which applies to pornography and accessing the internet for pornography or social media sites, would you read the Level 3 limitation the same way for that statute?
Well, first of all, that was in the subdivision 15 was enacted in 2008. Was enacted against a slightly different background with a slightly different legislative history, but I think I would say, and also as a textual matter, if you break that down in sort of the sentence diagrams that we did in our reply brief, subdivision 15 would actually be A and B or C or D. It's got 4 conditions going on as opposed to just the 3. But I think the SARA statute there, the SARA-like statute there, would be susceptible to the same ambiguity. So one would have to consult the legislative history of that provision and the purpose of that provision to see what the legislature's actual intent was. And I think when you do that here with subdivision 14, it really does embrace the state's reading.
Well, I saw a Supreme Court decision, I think at a Wyoming county, that made the distinction based on the fact that there's a comma in 15 after, you know, before you get to the limitation, right? So it says, of the correction law, comma, and the victim of the offense was, you know, making it a somewhat different reading, which struck me as interesting, particularly if you look at Penal Law 6510-4A, which I think you describe as a parallel provision, which actually has commas in it, that this provision doesn't. So it seems to me if I read 6510-4A, it gives me more of that pause that section 15 has, because there's a comma before the additional language.
You're right, it does give you more of that pause, but I would think that I think that there's a reason in the context of this statute not to say that ambiguity is definitively foreclosed by grammatical devices and grammatical precision. I mean, Sarah is an awkward statute on any reading. It's supposed to complete the sentence, the State Board of Parole shall, but it's actually a full sentence in and of itself. It's kind of awkward to have the is released clause after the list of criteria than before. And if you want to talk about legislative precision, there's a further oddity in the provision that you mentioned, Your Honor, the probation provision. The list of enumerated offenses is actually a little bit different. I'm not sure if it was a typo or what it was, but in the list of enumerated offenses for Penal Law 65, it talks about penal law, blah, 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 or Article 235, whereas in the Sarah provision at issue here, it's the same thing except for Article 135 instead of 235. So I don't think this is a statute that's really demarcated by attention to detail, and I think that's why it's so important to consult its remedial purpose. And for 3 reasons. The remedial purpose of Sarah...
Well, but don't you have to actually insert language into that provision that isn't there so that it would say something like, where a person is serving a sentence for enumerated offense and the victim's less than 18, or where a person has been designated a level 3 sex offender? Don't you have to really insert the or where a person in order to get to the reading that you propose?
You don't have to. That would be a much cleaner way of doing it among many cleaner ways and more explicit ways of, frankly, adopting either side's interpretation in this case.
Didn't the Fourth Department actually concede that you would be rendering some language superfluous?
Well,
if you follow your proposed interpretation?
Yeah, I did see that language in the Fourth Department opinion, but I don't think that's right. They were focusing on the phrase such person in what we've been describing as the C criterion of this 3 criterion list. But that phrase, such person, does not become superfluous on our reading. Something is superfluous if you could strike it from the text and everything else would be the same. The word such here does have a purpose on our reading. It refers to the previous use of the word person, which is a person in the clause where a person that comes before the list of statutory criteria. Now, to be sure, that use of such is not what one might call a greatly particularizing use of the word such.
Yeah, but it's not, no, it's not just a person. It's a person doing something, right? It's a person serving this sentence. It's not a person in the ether without some connection or relevance to something.
That is one reading, and perhaps that's even the more natural reading, but that's not the only reading. If you think of these...
But you're really arguing it's beyond some mere drafting error or some clumsiness or, gosh, we wish the legislature was a little more precise. You're asking us to look at this and say, the legislature understanding what is a common phrase in legislation. It's not that there's something unique about it. This common phrase of such person, and this is a typical, well-understood rule of construction would refer back, that somehow the legislature ignored or chose to inject all of this confusion into the statute. And that's my problem with your construction.
Well,
if it was a term that perhaps is unusual and not so well understood, I think you would have a very different argument.
Well,
but such person refers back to something. And the person here is the person serving the sentence, et cetera, et cetera.
Well, Your Honor, it depends on where you put the sort of verbal stops in the sentence. If you read the Sarah provision as where a person, A, serving a sentence for an enumerated offense, and B, the victim of such offense was under 18, or C, such person has been designated a level 3 sex offender, is released on community supervision.
But the such person goes back to the person on the enumerated offenses.
No, then such person goes back, if you kind of think of a letter A as being placed in between the word person and the word serving, then such person goes back to that person, that sort of reference person, listed at the beginning of the statute. It does not add a lot of particularizing detail.
No, then it would actually say a person.
Well, they could have said a person, but they didn't have to. And I don't think I can do much better than the 5 federal appellate decisions.
I agree, you can't do much better, you're right about that.
So does it make sense, though, if you can parse the words and you can say, okay, it could be read this way or it could be read that way, then let's just assume that you're right. It could be read either way. I don't know if I agree with you, but let's assume that that is the case. Don't you have to look at beyond that to what makes sense? So here you would agree, for example, that there are level 1 and level 2 sex offenders who have offended against children only, right? And this doesn't apply to them. And so,
Well, it applies to them to the extent they're currently serving a sentence for an enumerated offense.
Right, but I'm saying that if they're not serving an enumerated offense, it doesn't apply to them. They're not subject to the residency restriction at all, whereas any level 3, right, under your interpretation, would be subject regardless of whether they offended against children, right?
Well, here's why I think, yes, you're right, Your Honor, and let me tell you why that's rational for the legislature to have done so, again, to further the purpose of this remedial statute that this court's cases have always said is supposed to be read to embrace its purpose as far as the text allows. There are 3 reasons for that, and then I'll try to reserve the remainder of my time. Number 1, as a group, level 3 sex offenders pose the highest risk of recidivism and threat to public safety.
Right,
and so
but couldn't the legislature, again, getting back to just my previous question, have considered how long ago it was that they offended? So here, again, you know, you could have a level 3 sex offender who hadn't offended for 25, 30 years, and couldn't the legislature have reasonably made the determination that we don't have to worry about that person?
Well, I just want to be clear. We are talking about, everyone in this case is talking about folks who are under DOC's jurisdiction, and they're there because they've committed some offense, even if it wasn't a sex offense against a child. But the legislature could have done that. But they also could have done, which we think they did, and we think this court's cases about how to read remedial statutes compel the reading that they did. It was rational for them to exercise caution to keep all level 3 sex offenders away from minors whenever they came within DOC's power and jurisdiction to do so.
But this is a mandatory condition, right? So even if this doesn't apply and you have a level 2 sex offender or a level 3, if their reading is correct, and we were to affirm, the board could still impose this as a condition based on the particular circumstances, right?
That's right, Your Honor. The board can impose this on a case-by-case basis.
Thank you, counsel. Counsel?
Your Honors, the attempt to find ambiguity in the phrase "such person" is quite remarkable here. But what I find most telling is that the 4th Department in People ex rel. Garcia Villanucci found ambiguity in the statute and said what it could mean, and the Attorney General's office has rejected that. And by the same token, the 4th Department has rejected the Attorney General's office attempt at ambiguity. Because the 4th Department said quite correctly, such person is not a person. If they meant a person, they would have said a person. Such person has to be something more than that. And by the same
Tough, though,
token,
you know, the Second Circuit, I love the language they use. They said such is a rather slippery word. It's a tough one. That's very, very tough to be so definitive on that. What I struggle with here is not the application of that slippery word, but really, if you get to the legislative history, what does it mean? Can you address that?
certainly, Your Honor. I think that the legislative history, let's take a step back.
Go ahead.
We had a statute enacted in the year 2000 that applied at the time to all levels of sex offenders, including level 3 sex offenders who had victimized a child. When the legislature amended the statute in 2005 to add the provision, or such person has been designated a level 3 sex offender, they were not adding to the statute's purview level 3 sex offenders who had victimized a child, because they were already part of the statute. The people they were adding were level 3 sex offenders with an adult victim. boggles the mind that the legislature enacted a statute to protect children initially and focused it solely on individuals who had victimized children, something that makes perfect sense. But then, according to the Attorney General's office, when it amended the statute to add level 3 sex offenders with an adult victim, decided to impose even greater restrictions on those offenders than had been imposed on individuals who had actually victimized children. When in the first iteration, they didn't think children needed any protection from level 3 sex offenders with an adult victim.
It seems there was a...
And if in fact, that's what the legislature intended to do, that they in fact were having a departure from the initial statute, insofar as they were going to henceforth subject level 3 sex offenders to greater restrictions than had previously been imposed, there would surely have been something in the legislative history of the 2005 amendment that would have reflected that. There is nothing in the 2005 amendment that reflects that. Mr. Ginsburg is putting everything on the fact that, various and sundry letters and the enabling.
There's a lot there.
Says,
slow down. There's
Yeah.
a lot there in the legislative history.
There is.
Excuse me.
Sorry.
That's okay. There's New York City Civil Liberties Union opposed it because it would apply to all persons designated L3.
That's
seem rather
correct.
remarkable to you?
Not at all.
Okay.
What the Civil Liberties Union was referring to was simply the fact that henceforth all level 3 sex offenders, not simply level 3 sex offenders with a child victim, were going to be subject to this prohibition. That's what that's a reference to. It is not a reference to the supposition that the Civil Liberties Union thought that henceforth level 3 sex offenders would have greater restrictions placed on them, including those who had never victimized a child. So when they say all, they mean those with a child victim, those without a child victim. That's all. That's the total. It had nothing to do with whether that restriction was going to be imposed for life, for as long as you were a level 3 sex offender and were on community supervision for any crime, or whether it was only going to be imposed as long as you were currently serving a sentence for an offense designated in the statute.
I see. Thank you.
And
If the legislature had wanted to apply to all level 3 sex offenders, regardless of whether they had committed an enumerated crime, they were being released from that, could they have put that in the executive law provisions relating to level 3 sex offenders?
I suppose so, but I think what it seems to me
Well, in
clear.
terms of how long they have to register for and, all those things, wouldn't it make sense to put it there?
Certainly, it would have made some sense, and it's not there. But I think if they had actually intended in Executive Law 259C14 to make greater restrictions on all level 3 sex offenders, if they had intended that, they simply would have written the amendment to say, where a person has been designated, notwithstanding either, where a person has been designated a level 3 sex offender, or where a person serving in a sentence for an offense and the victim is it would have been the simplest thing in the world to have written the statute in a way that reflected the alleged intent that Dox is claiming exists and which does not exist. And I would get back to such person because there's no way to get around it. This is not, such can sometimes be a slippery term. I agree. It's not here. You have a phrase where a person serving a sentence for an offense defined in, et cetera, et cetera, et cetera.
Well, there's no breaks there. It's a slippery term if you got a few persons to choose from. but there's only one person here.
Yes, Your Honor. It can be slippery where it literally, when you look
It's
back,
unclear who's the such person
who
you're
such
referring to.
person is, it can be unclear. Because
That is
it's not unclear here. It's clear as day, as the third department found. And the fourth department, which, the Attorney General's office is not defending their interpretation, said, well, you can simply chop up that phrase, that integrated phrase. We can chop it anywhere we want. We can say a person serving a sentence, a person serving a sentence for an offense designated in, a person serving a sentence for an offense, and the victim is no, that's not how anyone would read this statute. Such person is the only person it could be, a person serving a sentence for an offense defined in.
Thank you, counsel. Counsel?
Just a few points in rebuttal. First, on the textual point, I think I would have to refer to this court's own characterization of Sarah in the Gonzalez case, where it said that Sarah applies, quote, based on either an offender's conviction of an enumerated offense against an underage victim or the offender's status as a level 3 sex offender.
Did we have this issue before us in that case?
It wasn't squarely before you, but you did have occasion to parse the statute as you did, and that's the result that you came up with. I think that is at least some evidence of ambiguity. I would like to turn again to the statute's purpose. Applying Sarah under the state's reading would cover actual child victimizers that petitioner's reading omits. Namely, it would cover level 3 sex offenders on community supervision who have previously served a sentence for an enumerated sex crime against a minor. Petitioner's reading doesn't cover that. The state's reading also covers, unlike petitioner's reading, level 3 sex offenders on community supervision who have previously served or are currently serving a sentence for an unenumerated sex crime committed against a minor. And those sex crimes are heinous in their own right. They
But if the
include...
legislature wanted to do that, then all they have to do is take out the enumerated, the language that they were serving, that they were most recently serving time for those offenses.
The legislature could have done that. There are any number of ways that they could have written the statute differently or more clearly, but the line that's being debated here is between all level 3 sex offenders on community supervision and those who are serving a sentence for an enumerated offense, and drawing that dividing line frustrates Sarah's remedial purpose, because both enumerated and unenumerated sex offenses can have minors as victims. And I see my white light is on, so I'll try to close with this. Just 10 days before the legislature amended Sarah, it enacted the unenumerated offense of compelling a minor into prostitution. It is implausible to think that the legislature wanted to exclude from Sarah's domain a sex offender who is in the highest general risk category and who is currently on supervision for that very offense. Again, compelling a minor into prostitution, but that is what petitioner's reading gets you. The state's reading should prevail.
Thank you, counsel.